interested in doing it for your time and commitment to this issue. Also, before I get started, just a little plug for Law Week, which is coming up at the law school on the week of April 18th. This year, the theme of Law Week will be access to justice. And so I know just because you're here, you're interested in this topic, so I would encourage you to get that on your calendar. And as an added incentive, we will be offering free CLE credits to attorneys that will be geared towards access to justice and promoting your work in this area. So more forthcoming on that, and of course the Supreme Court will be here for oral argument as well. So a week of April 18th to 22nd, plan on coming to the law school so we can give you some free CLE credits and talk more about access to justice. So Angie, I'm trying to forward my PowerPoint. And let me try one more time. Oh, here we go. Okay, wait. Somebody forwarded it. It wasn't me. I'm going to try. Okay, why don't you go ahead and forward it, Angie? It's not working from my end. Okay. So limited scope representation. And let's talk just really high level. And what I'm going to do, just so you know what the outlines of the presentation are, I'm going to start really high level, talk to you about the specific rules of professional conduct, and then Mars, who we're just delighted to have with us, is actually in the trenches doing it, boots on the ground, and he's going to give you some really detailed guidelines and guidance on how to do this consistent with your ethical obligations. So, Angie, is there any way I can work this?
Give it a try again, Jordan. Just try clicking.
I tried clicking. I'm trying my down button. Is that going to...
No, try the right arrow, and if that doesn't work, I can see your mouse moving. So.
Okay, and I apologize for this. I'm looking for. Yeah, I don't have a.
There we go.
Oh, is that me? Okay,
yep,
so limited scope. I apologize for the technical glitch. Okay, so here's what we're going to do today. We're going to, first of all, define it. What is it exactly? For some of you, this might be very remedial. I know a lot of you know this, but we're going to assume nobody knows anything because we want to really encourage you to understand it and do it well. Next question is, when can I do it? Obviously, there are ethical limitations on when this type of representation is appropriate, and that's what we're going to talk about today. What do the rules of professional conduct require when I engage in limited scope representation? And of course, we'll take that one step further. We're going to talk about what the floor is, but we really want to talk about best practices. That's really what we're all after, but we'll certainly tell you where the floor is, what's the minimum you need to do consistent with the rules, and how do I anticipate, recognize, and address potential issues. And Mars is going to be doing the heavy lifting on that, as I said, because he is heavily engaged in this work already and can give you a lot of great feedback and guidance on that. So next question, what's the goal of Montana limited scope representation? So it's a very intentional move on the part of our state Supreme Court. And the goal is to increase access to justice for low and moderate income Montanans. As some of you may recall, if you were here in Montana when limited scope representation was first proposed, it was a little controversial. Many states are moving towards this model, and the goal really is to address this gap, this delta in legal services. It's not just the poorest of the poor anymore who have trouble accessing lawyers, particularly in the civil context. Of course, for criminal work, we have public defenders and we have people can be appointed by the court. We don't have a civil Gideon, if you were. So it's not just the poorest of the poor anymore. It's moderate income folks, and it's middle class folks are having trouble getting access to legal services just for basic human needs, family law issues, landlord-tenant issues, access to government benefits. And that was the goal. And so what's the goal of this presentation? We want to encourage and support you in your efforts and your interest in providing pro or low bono limited scope representation. So we're going to hopefully give you the tools you need to get started. However, with the caveat, only when appropriate and consistent with your ethical obligations. So what is it? You might have also heard the term unbundling. Of course, we start from the premise as lawyers that when we take something on, we are taking on the whole enchilada, being the whole scope of representation within the area we define. So if I take on your family law case or your creditor rights case, there's an obligation, a professional obligation to do everything, the full complement of legal services that goes with it, which is counseling, court appearances, writing letters to opposing counsel, dealing with opposing counsel, appearing in court if necessary, filing pleadings. And that's how we've always understood legal services. LSR is unbundling those and trying to break down legal representation into its constituent elements so we can deliver part but not all of that when somebody either doesn't need full representation or when they simply can't afford it.
And Jordan, if I might just add, I look at unbundling as sort of a a la carte option for legal services. Like you said, instead of handling the entire case from start to finish, the lawyer may handle only certain parts. For example, lawyer might provide legal advice to prepare the pleadings or work on a child support calculation or something like that, and then the client just handles everything else. And if I might add, I do have a separate corporation called Montana Legal Advisors that we've started to deal with just limited scope representation of people that want some advice and some help to get through the legal system, but they're really do-it-yourselfers. And because of the internet and everything's learnable, there are a lot of people out there that want to try and get through the system themselves, but they just need a little help and guidance. And so that's what my corporation does. But we have a list, like a menu of different services that we provide and then what we charge for those services. So when the client comes in to Montana Legal Services, they know what it is that we're going to do for them and exactly how much it's going to cost. And then that's the deal. And we'll talk a little bit more about how to structure that later. But but it's kind of like a shopping or a menu that you might get at a restaurant. What do you want? And you can order whatever you want off the menu, and you know how much it's going to cost.
Yeah, and that's a great way. Thank you, Mars, for thinking of it. It's unbundling, but it's not just unbundling. It's also identifying what are discrete parts of this type of representation. Of course, Mars is heavily involved in the family law context and also some estate planning. And so I think one of your first tasks, as Mars suggests, is think about what you do and how can it be broken down? What are its constituent elements? What are the pieces that can be discreetly sort of carved out that you could actually help somebody with? It could be, just negotiating part of it, or could be drafting a pleading. And so it's really going to be specific to a particular area of law, but I think what we're going to see is most often it's going to be in the family law context. The latest statistic I heard is that upwards of 60% of family law cases in the state of Montana involve at least one unrepresented, one pro se litigant. That's an astonishing number. And so make no mistake about that, this also helps the court. The courts want to increase access to justice, but guess what? They want lawyers involved, particularly at critical junctures in the process, in family law in particular, because lawyers make cases run better. They honestly do. They can save the court time, they can save the litigants time. So as Mars is suggesting, somebody can come in and identify what is it they can do, him or herself, what is it something that would really benefit from the assistance of legal counsel, and it does help the courts. The courts' dockets are clogged with family law cases, and so it's helping low-income Montanans, but it's also helping the court. So another way to think of that as well. So as we've just described, less than full representation is authorized under our rules of professional responsibility. This is not the case in all jurisdictions. There have some jurisdictions have taken the lead on this. We were one of the first jurisdictions to sort of jump in that pond. We waited till a couple other people did it to see how it went for them. But I do think this is where law practice is going across the United States. But it's the big if, the caveat, if the client's interest can be adequately protected. So we don't always get to do it. We have to make that analysis because there are going to be some cases that require full representation. So just by way of history, Montana's, our court revised the rules relatively recently, but we've lived with them for a while, which is nice. So we have a bit of a track record. And so they had to do two things. They had to revise our rules of professional conduct and the rules of civil procedure. And here are the rules that were amended. For today's purposes, I'm only going over the rules of professional conduct listed there, but I've listed the rules of civil procedure, and maybe Morris can touch on those later if necessary, but you need to go look at those as well. And those obviously have to do with lawyer signatures and what the representations are, but I just want to be clear, I'm not covering those, but you do have those, so you'll need to check those as well. Oops, I just got ahead of myself. Again, the specific purpose, as articulated by our court, was to address unmet legal needs in our community. So let's get into the details of what the court did when they amended our rules. So here's our former 1.2C. 1.2C, of course, is the rule that defines the scope of representation. How are we allocating as authority between lawyer and client? And here's the interesting thing. 1.2 has always said that we can limit representation if it's reasonable under the circumstances if the client gives informed consent. Because here's our current version, just added 2 words. So the real question, actually, when our court revised these rules is whether it was even allowed, and there's an argument it was already allowed, but now the court has sanctioned it and said, yes, you can do it, and we are giving you the go-ahead and giving you the tools you need to identify when you can do it, when it is ethical, but also some tools to help protect yourself in the event of a misunderstanding, because of course, if you take on a case and there is a misunderstanding either between you and a client or you and the court as to what your role is, you may find yourself in for the whole deal. So hopefully what we're going to tell you is how to make sure that you're protecting client interests and protecting your own interests as well, so you're encouraged to do this. The next part of 1.2 that was revised was, here's an addition to our rule. So there was no subpart 1. Here we go. Okay, so it tells us, this is the writing requirement for limited scope. So from my former slide, you'll recall the only words that were added were in writing. So you can do this, you can limit the scope if it's in writing, and this rule tells you when, now that you can do it, when you have to get the client's informed consent in writing. So your default is always going to be client consent, informed consent in writing. And then the court has carved out a couple instances in which you can forego the writing. We'll talk a little bit deeper into this, that I think writing is always a good idea as a best practice, but here's where the floor is on the rules. So your default is you have to get the client's informed consent in writing, but the court has provided us a couple instances in which you don't. Again, the goal is encourage attorneys to provide pro bono and low bono services to fill that unmet need. So here's where you don't need to get the client's consent in writing. It's just a telephone consultation. If that's all you're doing, that's okay. If you're participating in a nonprofit legal services program, for example, one of MLSA's drop-in clinics, any kind of program like that, and you're only providing information and advice, you're not agreeing to take on a representation, or preparing forms, for example, at a self-help legal center, if you're one of the attorneys who staffs that, or if the court has appointed you for a limited purpose. Of course, this is a court tool as well, and now that we have authorized limited scope representation, you might find that judges who are wise to it also know that they can appoint you more easily, and you're going to have less of an objection that this is going to be unduly burdensome to you. Okay, so here's your translation, and these slides will be available. Your threshold, your absolute threshold inquiry, to make sure this is consistent with your ethical obligations, it must always be reasonable under the circumstances. Obviously a very fact-intensive and individual analysis, but it's like the analysis you do anytime you take on a new representation to figure out if you can even take this on. Is it within your expertise? So you need to figure out, does this case qualify? Is it amenable to this? Because of course the ultimate obligation is to always protect your client's interests. Your default rule, as I just told you, is that you must get informed consent in writing, and Mars is going to give you some great best practices and guidelines on what informed consent needs to look like to make sure everybody understands what the parameters are. So here's your formula. If it's reasonable and you have written informed consent, you are authorized to engage in limited scope representation. And here are your exceptions. Phone consults, limited to the phone consult, limited assistance through a nonprofit, filling out forms, working in a clinic, and court says so. That's the exception to everything, right? Court says so, you do it. So if court says you're appointed for this purpose, you don't have to stop and get written consent, informed consent, but still not a bad idea to do it at some point. Okay, some more amendments to 1.2. No former subpart 2, so here's some new rules, new as of 2011. And here's why I say best practices is always get it in writing signed by a client. So your default, always in writing, except if you fall in one of those 3 categories. And then the rule says if you get informed consent and the client signs it, you get a whole bunch of presumptions that are going to arise, and that's why I'm going to say always get your client to sign it, because why not avail yourself of these presumptions? So your client signs it, the presumption, it's limited to what is in the writing, and you do not represent clients in any other matters. So you see what this does. By default, if it's not signed by the client, there could be a presumption in the client's favor that you've agreed to do more than you actually took on. But once the client signs it, now it shifts to the client to prove otherwise. So this is a way of protecting the client and protecting yourselves by getting it signed by the client. Okay. So here's your presumptions. If it's writing signed by the client, it's limited, and you don't have to do anything beyond that. So let's just drill down a little bit on the written consent requirement, because the rules use slightly different language. There it is. One is informed consent, one's informed consent confirmed in writing, unless an exception applies. And then when you have a writing signed by a client, it's going to trigger those presumptions. So here's potentially 3 types of documentation. I actually interpret 1 and 2 to be the same. That is written consent, so that's broadcast. You've written something, or the client writes it. Usually you're going to write it, and you've confirmed it with the client. And then the third situation is what we were describing when you have the writing and the client actually signs it. I'm a huge fan of not just a signature at the end, but initials on every page of the document, or even every paragraph of the document. Certainly critical paragraphs. I think it's a really good best practice to go and actually get initials on everything, just like when you buy a house, right? They make you initial everything. Why not do it in this context as well? Okay, so some best practices. This is a little bit of recap. I just say rules don't require all the LSR agreements to be signed by a client, but why wouldn't you? Because it triggers the presumptions. It's going to protect your client as well. And Mars is going to give you more on this, is what needs to be in that actual document that you are going to get signed by a client, because that's your best practice. But here's a couple things. So facts and circumstances as you understand them, the information the client has given you. Also requiring a client to tell you, and when something comes up, I think particularly in the family law context, that can be very dynamic. Things happen, and things happen quickly, and put it on your client to let you know, because if something major happens, it might not be reasonable to continue as a limited representation, in which case you either need to take on full representation or find somebody who can. And tell your client, here are the things that I have evaluated that make this a reasonable representation, and here's the things that could change my analysis. Okay, so you've done all that, but don't forget, you still, all those core obligations, even though you've limited your scope of representation, you can't limit your professional ethical obligations to the client within that universe. So they're all still there, what I call the 5 C's: communication, competence, confidentiality, control, and identifying conflicts. These are all your core obligations to every client you take on, regardless of the nature of that representation, and that continue throughout the representation. So always making sure that you're tending to those. Competence, you know what that is, and so the legal skill knowledge to reasonably necessary for the representation. So in this particular case, it's what is reasonable for limited scope representation. Okay, so it's the same box. It's the same box of obligations you owe to your client, but in that different scope. Engagement letters. I'm going to actually skip over this slide. I'm going to let Mars address that because he has a lot better stuff to say than I do, because he actually does this. All right, 2 rules I'm going to touch on. I'm going to hand this over to Mars. 2 big ones. These are the other amendments to the rules of professional conduct that are to facilitate and encourage limited scope representation. Of course, 4.2, we all know what I call the no contact rule. You are absolutely forbidden from talking to somebody who is represented by counsel in that matter, about that matter, unless opposing counsel agrees or the court permits it. It's that simple. Lawyers are the gatekeepers on this. We can debate whether this is a good rule or not, but the lawyers are the gatekeeper if somebody is represented. So, of course, the question comes up, if somebody is only represented under a limited scope agreement, what are the obligations? Because you need to be mindful of this is a clear-cut ethical violation if you get on the wrong line of 4.2, because there are no exceptions. Opposing client can never ever consent to your contact. Only the lawyer can. So here's what the court has given us. To the extent somebody is proceeding under limited scope representation, you can protect yourself from an allegation of a violation of the no contact rule by giving the opposing party or lawyer a written notice of appearance that defines the scope of your representation. So what that means is that the party is considered unrepresented, except to the extent that you advise otherwise. So just be mindful of that, because the lawyers can put you on notice saying, hey, I represent. So you need to communicate, if there's another lawyer with the opposing party, to what extent you are in the representation to avoid running afoul of 4.2. Then quickly, 4.3 has its counterpart to that. Again, so somebody dealing with unrepresented persons, we have obligations to third parties, and of course those ethical requirements is we need to clarify our role with unrepresented parties to the extent they're confused, and we can't give them legal advice except advice to consult with an attorney. And so 4.3 gives us that counterpart, and it tells us when somebody is considered unrepresented for the purposes of 4.3. And with that, that is my discussion of the ethical rules, and now I'm going to turn it over to Mars to give you some practical advice based on his depth of experience in this area.
Well, thanks, Jordan, and thanks, Angie, for putting us on and inviting me to give whatever comments and ideas that I might have about limited scope representation. As I said, I have a corporation called Montana Legal Advisors that I started that's a subsidiary of my law firm, and it's set up to deal with, as we've just been talking, very limited representation of individuals that want some help or advice on how to get through the legal system. I just want to make a point, an ethical point, and I'm sure it's obvious to everybody, but always keep in mind that it's the representation that's limited, not the legal assistance. In other words, you still have the same duties, obligations, and standards of care in whatever that particular issue is that you might be representing the client about. So it doesn't mean that it's substandard legal representation, just means that your representation is limited and restricted to whatever the agreement is between you and your client. And as Jordan said, I mean, this area really does allow a potential benefit to lawyers, to the clients, and to the courts. Lawyers, I think, now have the opportunity to obtain clients that they that who would otherwise be representing themselves, and to be able to reach, I think, an untapped market and generate additional income. I realize that this is a low-income pro bono type of presentation, or it's to get people involved in that particular area of the law. Montana Legal Advisors charges full rate. We're not a cut rate service. Our menu is based upon what we think our hourly rate would be, or what we would be charging based upon our hourly rate for whatever the service is. And we have tapped into a market. So, I mean, just because we're providing services where we're charging the full amount, I mean, whatever we do there, that certainly applies to low income or pro bono kind of work. But just to be clear, we're not doing that in Montana Legal Advisors. So when people walk in, they're willing to pay a regular fee for whatever that particular service is. And hence, for some of you who might be interested in pursuing this particular area of the law more in terms of limited scope, I really do think that there's a market out there, because, the super rich can pay for all the services that they want. And my experience with people that I would think are super rich are, as long as you provide a service, they'll pay you for any bill that you send them. But if you don't provide the good service, they're not going to pay you. And then, the lower income people seem to have opportunities to have people help them out, and legal aid and whatever else might be out there. But there's this middle class, this, I say school teachers only because my whole family have been school teachers. The people that make that are school teachers, that make that amount of money that, they just aren't going to qualify for any assistance, but they're not super rich by any stretch of the imagination. So dollars and pennies count. And those are that income area are really the people that we're trying to market to, and who are actually coming into Montana Legal Advisors. So I do think that there's a market out there, and as limited scope becomes more popular, or at least more understood by the public, I think that lawyers can step in and provide that service. And as Jordan said, and then the courts too are thankful when things are done properly, and they can tell if the lawyer has had some input on, whatever the document would be or whatever. And I might make a point about ghostwriting too. That was one of the controversial issues when the Supreme Court was considering whether to allow limited scope. In other words, can a lawyer write a brief and ghostwrite it, and then give it to the client and have the client sign it as their work product? And the answer to that question is yes. And I would say, I would just tell you that I was against that, and wrote a letter to the Supreme Court. I mean, I supported everything else, but I was against ghostwriting because I didn't think that would be appropriate, but the Supreme Court decided that it is appropriate. So you can write a brief for somebody or do the legal research or whatever, and even though it's your work product, you can give it to the client and they can make it their work product. Of course, you want to make sure that they're responsible for whatever's in the brief in case the court is asking them questions about certain points of the law. So in your limited scope agreement, you might want to be clear about what service it is that you are providing, and so I'm going to talk about here in a second what services that you're not providing. So Angie, I don't have the mouse. Can you move to my first slide? Would be the next one.
Let's see, we have that one. And Martha, formatting from your presentation didn't stick with Jordan, so you're going to look at the same formatting that Jordan sees.
Oh, okay. So are these my slides? They're just not in color?
They're just not in color. I'm sorry. Yes, this is the first one, though.
All right, sorry. All right, I get it. All right, so as Jordan said, I have some ideas about what to put into an attorney-client agreement, and I'll just tell you that from a background standpoint, we did go to the states and look at examples after example after example of what other states were doing for limited scope representation attorney-client agreements. And a lot of states have forms where you just check the box and you sign it. They seem to be inappropriate, or at least didn't cover all the particular situations. So these ideas that I'm giving you are not necessarily my ideas. They're the ideas I have pulled in from other states. So what you, maybe Angie, is there a slide right before this? So no, okay, so this one. All right, so when you put together your limited scope agreement, you want to define exactly what it is that you're going to be providing, what service it is that you're going to be providing for the client. And I have to tell you, one of the issues that have come up is that we have had to learn how to say no, because, you know, for the 30-some years I've been practicing law, I mean, one of the reasons I even practice law is to help people, right? And so I always say, yes, I can help out there, I can do whatever. If you're truly going to run a limited scope operation, it has to be limited scope. And so you need to very clearly define the beginning, the middle, and the end, if you will, of what that service is going to be that you are providing for the client. And as Jordan said, make that very clear, and it needs to be reasonable, and it needs to be in writing. And then when they want you to do the one more thing or make the additional phone call or whatever it might be, and this is where we've fallen down, at least initially, but we've gotten tougher now, you have to say no or enter into a new limited scope agreement. So I would encourage everyone, because we're all probably in the practice of law to help out in some fashion. We probably have that sort of altruistic feeling about, you know, helping society. But if you're really going to do this work seriously and do it so that you don't get into trouble, you have to find that NO word in your vocabulary. And, you know, I mean, do it diplomatically, but you cannot get sucked into doing more stuff. And we've gotten sucked into doing more stuff in cases and learned our lesson. So once you define what it is that you're going to do for the client, then what we put into our agreement is, and we have some boilerplate language, is we say then that the client's responsible for all remaining obligations in the case, such as, and of course we have the, you know, the great legal language there, lawyer language, including but not limited to. So somebody may have other ideas out there, and, you know, you'd be willing to share them with me, but we'll always put in meeting all court-ordered deadlines, filing all necessary pleadings, fully complying with all discovery requests, obeying all court orders, communicating with the court and opposing counsel, and that's a big one, especially the opposing counsel, because one of the problems that we've run into, or that we ran into in a case, is that a client came to us just for a child support calculation, that's all. But in the case, there were issues involving maintenance and I think maybe property division. It was an enforcement of decree kind of situation. And it got confusing, quite frankly, dealing with opposing counsel, because, I mean, we knew about the other issues, but our limited scope agreement said we're only doing child support. So the poor attorney would call us and want to talk about the maintenance. We'd have to say no, and that was awkward and, you know, and kind of hard to do. And then, you know, some of that bled over from the client. And so, again, you got to, one of the problems, if you will, quote unquote, with limited scope, again, is defining that scope and then sticking to it. Next slide, Angie.
Mars, I'm sorry to interrupt. Yeah. We actually have two questions that would fit in well here. Do you mind if we take a quick break to get those out there? Okay, so the first one says, when considering whether or not to take a limited scope client, how much should you tell the client about what could happen in their case down the road when you're no longer there to help them without overwhelming them?
That's an excellent question, and I think the last slide here on this presentation talks about a case from California. Let me see if I can pull it up on my own little screen here. It's called the Nichols versus Keller case, and that's it's a 1993 case. And so, you know, this concept has been around actually for a long time in the country. And what that case says is that the attorney has an affirmative duty to advise the client on related matters, even if not asked. Now, that's kind of broad language, but I think it fits into the response to that question. You still have some general duties and obligations to the client as a licensed attorney to give them a sense of what else is out there. Now, you don't have to represent them on all the issues that you might identify or what might happen in the future, but you do have this responsibility to have basically a human conversation with them about their case and their life and how things might go. So I would say I mean, it's going to be a judgment call, obviously, but start with the premise you do have some affirmative obligation, at least according to that California case. There's no case like that in Montana. But I think it's reasonable. And as I was talking to Jordan right before we got on here, I think that holding in that case comes from the glaucoma case that I remember in torts, where the eye doctor performed certain eye exams but didn't do a glaucoma test, which apparently is a very simple, easy test to perform, and the eye doctor was sued and was found liable because it was an easy test to do, and it was reasonably foreseeable that an optometrist should perform that kind of test. So I think the same kind of principle applies here, at least according to that case would.
Yeah, and if I could jump in just for a second, I want to echo what Mars said. You still have a duty of competence, and part of your competence as a lawyer is knowing where that piece, that limited scope piece, fits into the bigger puzzle. You just assume that person in front of you knows nothing about how the system works. If they come to you, for example, for a child support calculation, you have an affirmative obligation to say this piece fits in here, and to advise them when, for example, you're drafting an order, when can that be revised, what does the law, where does it fit in that big framework of the law. Let's just use family law. You're helping them draft a parenting plan. You need to, I think, advise them of how and under what circumstances it can change, that, if it's an interim or if it's a final parenting plan, so the legal significance of that. So in answer to the question, if you're drafting something that's just an interim or something that could be challenged or something that might expose the client to further litigation, you have an absolute obligation to advise them, overwhelming as it may be, what could happen next, what might happen next, and where that little piece fits into the larger piece of the law and the larger puzzle of the law.
Right.
And as a follow-up, there was a question in the middle there that I will get to after this, but this is based on your answers. Someone has also asked, insofar as the limited scope requires advice about the big picture and other substantive areas of the law, do you charge for this too, or is such background included in the limited scope fee?
It would be included in the limited scope fee. We wouldn't charge extra for just having a general consultation, but that's our business model. I don't think it would be inappropriate to charge for it. I think, as Abraham Lincoln said, the only thing we have to sell is time. So either way, but we don't. It would be part of the package that they would order or pay for.
And then the last question, and we'll continue and save for the rest for the end, is if an attorney appears, quote-unquote, limited scope for a single specific hearing, is opposing counsel required to honor or respond to pleadings and papers sent post-hearing if a general appearance is not filed?
Pretty good question. The process is that you need to file your notice of limited scope representation before or simultaneously at the beginning of the hearing. In other words, you can't file it right before the hearing starts. If you file it after the hearing starts, you are then charged with general representation of the client. Okay, and so you got to know that timing thing. But in the rules, it says once, and then you don't have to have court approval to get out. You just file a notice of non-representation. It's not the right term that we use. I can't remember right now, but that it's been terminated. Your representation of them, that's what it is, has been terminated or no longer exists. Once you file that notice, then you're done. And so in theory, you would not have to respond to those pleadings, but it gets back to that no question, that no problem. When deadlines are running and you've already taken on this client, what do you do? But if you file a notice and give notice to the other side that your representation of them has been concluded, then you're out. You don't have to do anything.
Great.
All right, Angie, the next slide then. Okay. And this next point I think is important. State that you're relying upon their version of the facts and the status of the case, and that you are not undertaking an independent investigation to verify the information that they've related to you. And I'm not sure where that concept came from, I mean, which state, but you know, if you are doing general representation of a client, you do have some duty and obligation to investigate their version of the facts and to make sure that there's been some substantiation, or at least there's some reason to believe that their version of the facts might be correct, because you have Rule 11 ethical obligations to make good faith pleadings to the court. Here, with limited scope, if you're relying upon their version of the facts and you can contract for that, then I think you protected yourself. Now, it may not be 100%, but it gets back to, I think, a point that Jordan was making in one of her slides, that also put in there, and I'm going to add this to the slide at some point, put in there that if the facts change in some way or the circumstances change, that they have to inform you of that. They can't hold that back. And so I think that this is a good provision to protect you, because, again, it's limited. You're just doing this one service, and you're going to rely upon their version of the facts, and based upon those facts, you're going to move forward and take care of business. And again, I'm not sure it's a total fail-safe, but it can't hurt to have that in your agreement. And then we already talked about specifically describe the services that you agree to provide. And then we always put the fee amount in there, and of course they have the menu. They've already looked at that, so you always want to make sure that you describe your fees. Now, we have a flat rate fee for certain services, but we also have on our menu attend a deposition with a client. That we would do on an hourly rate, and so, I mean, our hourly rate could be negotiated, but our fee agreement then would reflect that we would charge them an hourly rate. And then we've had one client say, okay, but I only want to pay you for 5 hours, which again is a little awkward. If the deposition goes 6 hours, maybe you're going to give away that last hour just because you can't say no. but the client just wanted to pay for that, just paid that much money for whatever we could give them for 5 hours. And then state the services. This is kind of the reverse of what I was saying earlier about the things that the client will do. Then do the reverse and say, you will not appear in court. You are not going to speak with opposing counsel. You are not going to do whatever other things might have been discussed that they might have wanted you to do. So, it's kind of a three-pronged deal. Describe the service that you will provide, then tell in your agreement, get a commitment from the client that they are going to do all these other things, and then disclaim from your standpoint that I'm not going to do all these things, and I think you'd be covered. And once you do your first agreement, then it's easy to just add and do your editing as different cases come in. What's the next one, Angie? Oh, okay. And this is just kind of the summary then of, and I already see a couple of things that Jordan brought up that I should add to this, but this is kind of the summary of limited scope. When we do our training here in the office, limited scope must be informed and in writing, must be served prior to or simultaneously with the proceedings. Changes in the scope must be documented. And so if you're going to add that I'm going to work on your property division after you said I'm just going to do child support, you want to make sure that you enter into a separate agreement. And as Jordan said, limitations must be reasonable under the circumstances. And then there's that Nichols versus Keller case about attorneys have an affirmative duty to advise a client on related matters, even if not asked. So
okay.
That concludes my slides.
We have quite a few questions to follow that up. So I will just read through those if that's all right. And I don't think there's any particular order. So the first is, do you enter or file a notice of appearance for a limited purpose?
Yes, you do. And you describe in the notice again exactly what your role is. And once you do that, you're in control of your destiny. In other words, you can get out anytime you want by filing that notice of withdrawal or termination of services, and the court can't say anything, can't tell you to stay in.
And then a sort of follow up to that, is there a draft or form of an attorney-client limited scope agreement in family law cases that is available to user view, as well as a limited scope notice of appearance?
Well, I'd be happy to share what I have. I think I'm the only one that I know that has a limited scope agreement that's fairly comprehensive. I've seen letters and things like that, but we have an actual contract. And somebody wants to send me an email, I will share it with anybody who wants it. And it's P-Mars Scott, P-M-A-R-S-S-C-O-T-T, so there's 2 S's, 2 T's, at pmarscott.com, so it's just the same .com.
And the next question is, can a limited scope attorney, say solely for the purpose of drafting child support calculation, provide an agreement that the attorney is not subject to subpoena and will not appear in court? Or can there be a penalty, time and a half, or something like that if they are compelled to do so?
Well, interesting. Since that might be a concern, I think if you put a disclaimer in your agreement that you're not going to appear, or even if subpoenaed, I'm not sure, quite frankly, how the court would rule on that. We don't have any hard and fast rules on any of this stuff. But again, I don't think you can go wrong with informed consent. I mean, maybe you're going to have to end up and testify, but you're not going to be in trouble because you resisted because it was in your agreement. So that's another point here that I should probably just write down. And there's another issue that maybe would come up. I don't know the answer to that. Maybe Jordan has a comment.
Well, if you get a subpoena, obviously you have to show up unless you move to quash a subpoena. But you could make it really clear that, to the extent, to the extent that you are called on to participate further beyond the scope of the agreement by some third party, including a court, that there may be an additional charge for that or additional. And I'd have to think about whether you can actually, whether that would be overreaching to say if I'm subpoenaed to appear as a witness that you can charge the client for that. So I'm gonna withhold on that, but I will say if you get a subpoena, you have to follow the subpoena. So I would think you'd have bigger problems than whether you get paid or not if you decide not to answer or honor the subpoena. But you might
well
go ahead.
Put.
Yeah.
I was just going to say, well put. Yeah, that's very clear. You're right.
Yeah, so that's your obligation. I don't know. What I'm trying to think is technically, could you do it? Maybe, but put yourself in the court's shoes. How would that look? And do you really want that piece to come up in front of a court that you have tried to charge a client for extra time, if you will, for courtroom time? So my gut is probably not worth that. But making it clear to the client. That maybe that's a condition under which you terminate the representation. If they start trying to pull you in that way, you can say, well, now I'm a witness, so I can no longer represent you, or I will terminate our limited scope. It kind of depends who's subpoenaing you, I guess.
Mm-hmm.
Okay, and we've got actually quite a few questions coming in, so I'm going to try and bundle them together. And then the ones that don't get answered, because we're running a little short on time, I'll address after the webinar individually and connect people as I can. So the two that are related has to do with whether the notice of appearance is still necessary if the agreement is to ghostwrite a single motion. And along with that, what is the best practices in terms of submitting a notice of entry of appearance for the same type of situation?
So, Mars, I'll take a stab at it, but you follow up. I don't think you have to file a notice of appearance to ghostwrite. I think it's only when you are actually showing up for a proceeding and a representing, or if your name's going to be on a pleading. That's my understanding, is that you don't need to make yourself known, because that is what ghostwriting is. But Mars, I'd be interested in your take on that.
Yeah, I agree 100%. Ghostwriting is separate from making an appearance. So your ghostwriting is, you don't put your name on the document that you wrote. That's the point, and that was my objection, because I thought that was work product. But you just you prepare the document, you just hand it to the client. You're done once you hand it to the client. What they do with it, you don't know. Maybe they tear it up and throw it away, or they can file it or whatever. But you don't have to make appearance to do that. That's right.
Yeah, so just if you're showing up in court or your name's going to be on some documents, that's when you tell the court, hey, I'm over here, and opposing counsel, but I'm only over here for this particular hearing or this particular motion, and once this is done, I'm out, and whatever that thing is. So it's literally making an appearance somehow, but for other things, behind the scenes things, you don't need to make yourself visible, if you will.
And related to that, can you provide us with a reference to the rule or case that allows the attorneys to ghostwrite a document?
Well, it's the Civil Rules 11, right? And the amendments that were made to the Rules of Civil Procedure?
Yep. Let's see here.
Yeah, and that's on one of my slides. Go ahead, Mars.
Yeah, Rule 11E. Attorneys may help draft documents and not sign them without sanction. In doing so, the attorney may rely on self-represented person's representation of the facts unless the attorney has reason to believe that such representation are false or materially insufficient, and then the attorney has a duty to make an independent, reasonable inquiry into the facts. So actually that's a little more detailed than what I said before. But yeah, it's Rule 11E.
And I think this will have to be the last one. And then there are a couple that we haven't addressed, and I will take care of those after the webinar. So the last question is, what if information was divulged to you inadvertently during your limited scope representation, and then you are subpoenaed to testify to those facts, facts that are not in the bounds of your limited scope agreement?
It's still Rule 1.6. That's my kind of flat out answer to that. You go to Rule 1.6 because all your duties are intact, okay? So the Rule 1.6 is not limited to client information as it pertains to the representation. It's all information a client gives you is protected by Rule 1.6 and cannot be divulged, and then there's of course the attorney-client privilege, unless an exception applies. So let's say you're talking to a client about a family law matter and then something comes up with respect to their bankruptcy, it's still client information. Okay, your duty of confidentiality is not bounded by your limited scope representation. So during that period in time, and you should make this clear to the client, I think this is part of your initial consultation, you need to educate your client about the rule of confidentiality and the attorney-client privilege, but also make it clear once the representation no longer exists, those rules are not in place. So your consult with the client related to that, that's all protected. But once you're out, and let's say client calls you then and divulges information to you, that is no longer protected because you do not have an attorney-client relationship. So it's bounded by the representation, not by the subject matter.
Okay, well, I think we'll cut questions off then because we're about 3 minutes before 1 o'clock. I want to thank Mars and Jordan for their time and expertise. We were really lucky to have both of them share their knowledge on this topic. The materials and a recording of the CLE will be posted to montanaprobono.net and the State Law Library, who hosts their own CLE library. Again, if you have any questions that were not answered, or if you have any follow-up, please don't hesitate to contact me. You can reach me at 543-8343 extension 207, or my email is awagenha@mtlsa.org. Thank you again. Please take a minute to respond to the survey after this CLE ends so that we can get your bar numbers reported to the bar for CLE credit, and so that we can improve future trainings and ask for some guidance on future topics that might be helpful. So thank you again, and I hope everyone has a wonderful weekend, and a special thanks to Jordan and Mars for their time.